Thank you for having me. I'm immensely grateful for this invitation. I feel that this approach of criminal lawyers when interpreting the jurisprudence of the European Court of Human Rights is very important. Maybe not, it is not the same level of interpretation as the scholar of international law, but it is very important approach that can develop a special issue of the judgment given by the European Court of Human Rights. And my presentation following, can I use? My presentation is about the prohibition of torture and other forms of ill treatment, as both are contained in the Article 3 of the Convention on Human Rights. And we cannot distinguish torture from other form of ill treatment that easily, so I will take care of both. And my idea is to highlight some general impact as I took this task seriously to find the role of Central and West and Eastern countries' legal system as a grounds for interpretation and development of Article 3. So there are several fields that could be established in this presentation, but as I have the limited time, I think that I will concentrate on the notion, somehow elaboration. I gathered also some interesting data about the frequency of the breach of Article 3, and I would like to make comparison between Central and Eastern state. On the other hand, Western states, and somehow we could see the line around 2010 that the European Court of Human Rights started to develop this approach toward Article 3 in respect to Central and European countries. It is very rare now to find those infringements against Western countries. So this is my first point, and based on those data, I would like to formulate somehow a hypothesis. And the second part, as I'm a criminal lawyer, I would like to concentrate on just a part of this ban, a prohibition of torture, in respect to legal actions in criminal trial. And I would like to observe, on the one hand, actions, selected actions, like hearings and selected actions during the criminal trial, and its impact on the final decision, and sometimes this ban and its interference on whole procedure, namely enforcement procedure, which is not that much connected with the selected legal action, but whole procedure, and it was given also by my previous speaker when it comes to this approach of the penalty, enforcement procedure, and overcrowding of prisons in Poland, Hungary, and other Central and Eastern European countries. So first, let me introduce those notions. So as we can observe, European Convention on Human Rights use the notion taken from the convention, but not European Convention, but United Nations Convention. It's just to remind you about this wording of Article 1st of the United Nations Conventions, because this approach is not directly, but somehow indirectly taken by the European Court of Human Rights. So we can find a pure interferences of this definition on Article 3 of the Convention. Speaking about the European background, I would like to also highlight the interference, and speaking about the future of interpretation toward Article 3. I see some interference between Article 3 and the rule of Strasbourg Court, and Article 4 of the Charter, the European, there is a framework, Article 4 of the European Charter on Fundamental Rights, as this is a ground for interpretation of Luxembourg Court. And at the end, Luxembourg Court tried to improve the standard set by Strasbourg Court. Of course, it is not that easy, as Luxembourg Court is dealing with this sphere which is rather limited. It means mutual recognition of judicial decisions. So the framework is broader in the case of Strasbourg Court. But nevertheless, it is another aspect of efficacy, effectiveness somehow, because the enforcement of judgment of Strasbourg court is 3 times lower than effectiveness of judgment of Luxembourg court. So when we speak about European countries, the tools given by the Luxembourg court, it's generally more effective. So I think that with this prohibition of torture and other treatments, we are at the point to transfer the approach given by the Strasbourg court through Luxembourg court and finding the way to, I would say, introduce this approach for somehow field of criminal law. Now we can observe this only in the cases of enforcement law and extradition and overcrowding of jails, especially in the case in the framework of mutual recognition connected with the European arrest warrant, as this is a ground for refusal, the breach of fundamental rights, and the threat of the breach of the prohibition of torture. So speaking about the context, I would like to also highlight the constitutional aspect. I know that this is not visible as the characters are too small, but here I would like to show examples how national system has adopted this prohibition of torture. And here we have some collection of articles from the constitutions of Central and European countries. So you can observe that this prohibition of torture and other ill treatments formula, they have been adopted. Of course, the wordings are not identical. So at the end, the approach by Constitutional Court is given not in identical way, especially when it comes to criminal procedure. Speaking about criminal procedure, we generally could interfere a principle that this prohibition of torture is a ban with the sanction of invalidity only upon the condition that the result, outcome of legal action has been introduced somehow in the final decision. So if not, this ban has not that strong significance for criminal cases. I will give you some example by referring to the cases, but this statement was also adopted by the European Court of Human Rights when it comes to Germany, in cases Yellow versus Germany or Gavgen, and there were further steps recently taken against Poland. I would like to address those approaches, which could create somehow dangerous tragedy when it comes to perception of criminal justice in Central and European unions, as the standards set by the European Court of Human Rights towards Central and Eastern countries are much higher than the standards applied to Western countries. Of course, the reason is sometimes connected with numbers. And now I would like to address this topic, as I have many of slides, because I wasn't sure about the time of my presentation. And I was prepared for 1 hour, but don't worry. But don't worry, I will resolve this issue. I wasn't sure, so I would prefer to go deeper, and then. But I would like to be strict with time, so I will stick with data. So I researched some data to found this statement why the European Court of Human Rights is somehow addressing more often Article 3 toward Central and Eastern countries. And here we can start by Hungary, as we are in Hungary, and you can see that following those statistics given by the European Court, we have 94% of cases in this favor of state, which is a very high number. I could say that I did my personal research, and I can say that Poland has worst results, so 97%, but it's not official data, so I cannot use it. I'm waiting for the official data of the court. So 94%, and then when it comes to the breach of Article 3, we have the 7.42% of cases when this breach of Article 3 has been allegated. And then we can make comparison with other states when it comes to Central and Eastern Europe. And in case of Albania, we have 80% of cases in disfavor of state and 5.50, so almost 6% cases connected with Article 3. When this article has been decided as infringed by the state in the given case. We have the case of Czech Republic, 81% and 2.42, which is exception in this part of Europe, as the lower indicator when it comes to Central and Eastern countries. And then we have the case of Georgia, and as you can see, it's a winner in the in the systemic infringe of Article 3. It's 25% almost, with the same 75% of cases in disfavor of Georgia, 90% against state in the situation of Greece, and almost 10% of infringe of Article 3. And then we have Armenia with also very high, level of prohibition of torture infringement, almost 20 and so percent. And the case of Croatia, 6.61%. And then now we move toward Western countries. So you can observe that this indicator is very low, just 1% in case of France. And in case of Germany, 2.3. In case of France, at the same time, we have just 70% of cases in disfavor of country, and in case of Germany, 50% of cases resolve in disfavor of Germany. And now following this western part, Italy, 2.36, and Denmark, 4 points. So you can observe clearly that the central and eastern part of Europe is much more frequent as a state when it comes to infringe of Article 3. So at the same time, there are many judgments against the state, so there's somehow presumption hidden through this behind this hypothesis. So it means that the tribunal is more reserved when it comes to Central and Central European countries. So I would say the requirements are sometimes high. I made some deep research in German's jurisprudence when it comes to evidence taking, and I must tell you that, honestly, as a lawyer, I think that the rules for evidentiary actions in Germany are very low in comparison to Poland, especially if they don't have to provide the court with the protocol official record. Just the notes of officers is sometimes enough as the outcome of evidentiary actions. So this difference of perception of whole procedure when it comes to the breach of Article 3, I must not tell you that this part of records, official records, it's very important when it comes to the breach of Article 3, because very often this formula of torture, inhuman, degraded treatment is connected directly with the hearing. So the record is the unique evidence of the given action. And in Germany, of course, some of them are admissible without record. So just going to the final conclusion, here we have also the Ireland, 2.5, and Finland, 1.2. So this is very clear that we have a very important role as a Central and Eastern Europe in this whole development. And I must tell you that the European Court of Human Rights has adopted a very developing approach when it comes to Article 3. So as a result, of course, the grounds are created by the principle of proportionality. We have this absolute ban of torture and other form of ill treatment, especially torture is absolutely banned. But at the end, in the cases and evaluation of other forms of ill treatment, this principle of proportionality is very deeply hidden behind the statement of the court whether this infringement has occurred or not. So at the end, I would like to concentrate, so not at the end, but being just concentrated on facts, on some cases of European courts. Also, it was not an accident that I have selected the cases connected with Hungary and connected with Poland, as I could research them deeply. So examining whole cases, because I did it when it comes to the breach of Article 3, in case of Poland and Hungary, we can distinguish 6 fields. The first one, it was my preference, are evidentiary actions, but the number of cases is rather low in this field. The second one is the application of preventive measures, especially detention on remand, pre-trial detention, and stops. Also, stops in minor cases are very frequent, connected with Article 3 in respect to Poland. I could research several cases during the last few years. And then the third area is enforcement procedures, condition of the imprisonments, execution, so this overcrowding of prisons cases. And the fourth is the punishment of life imprisonment without parole, which is somehow the case of Hungary last 10 years ago. And now it's became very hot topic in Poland, as the new law has been adopted with the one option for this life imprisonment without parole, and the law will be binding from October. So we can wait for the new decision of the European Court of Human Rights, which is obviously in line of the court decision that this regulation is not a law, it's not in conformity with the convention. And then also we have somehow issues connected with criminal law, but not just directly. So the abortion's rights, the Poland prevail in this field. We had this struggle with abortion rights. We have been struggle since 2010. And now, after 2020, with the right on abortion has been even more restrictive, has become more restrictive. I've noticed that we have more than 1,000 cases bind before the Strasbourg court, as in Poland, abortion is now not allowed in the situation of the formation of fetus. So it is not founded ground for adoption. There are still the authorization when it comes to the crime of rape has been committed against the woman. And the second, the condition that the life in threat of mother. So, but there's no any reason for abortion when it comes to the condition of fetus. So, and the last part, which is not connected with criminal law, but very interesting, and we have so much in common with Hungary, there are asylum cases, and there are very developing cases, especially mentioned before by Lily, the cases of pushbacks in Poland and in Hungary. We have the situation now in Belarus. So with criminal law, this is connected somehow, as this whole cases of pushback are sometimes connected further with the trafficking in human beings. So there are some hidden links with this pushback procedure and criminal law. So speaking about those selected cases, I wanted to concentrate on a few of them. And when it comes to Hungary, I would like to remind you about the case connected with evidentiary actions, namely coercive evidentiary actions. Case RS and the others, 2019. It was the case of the use of force by giving the urine samples by catcher. And this is the case very similar to Yellow case, very famous German case. And the standard set by European Court of Human Rights in this particular judgment is higher than in Yellow case. And the second example, I know that the time is passing, versus Poland. It is the case Nasir versus Poland. Al-Nasir versus Poland 2014. It was the first case when the allegation of torture has been adopted and confirmed by the court. And the second is very recent judgment, Ćwik versus Poland. And this judgment is also very strictly connected with famous German case Gavgen versus Germany, so Ćwik versus Poland. It is the case when the court decided that the torture cannot be, the evidence is inadmissible in the case of torture committed by private individuals privately when this whole confession, but not during the process, but taken in private way, has been performed before the trial. So this private document is not admissible following the court's recent decision. So I can just promise that in my written form, I would like to elaborate this further based on some very interesting conception of constitutive rules. It's a conception set in United States mainly. This is a concurrent conception with the conception of exclusionary rules. So thank you very much, and I'm looking forward to discuss with you during discussion part. Thank you.